Mr. Hubert, if you'd like to come up to the podium, please. We'll go on the record in People versus Hubert, case number 216168. The record should reflect Mr. Hubert's present here in the courtroom. If I could have counsel for your appearances.
Morning, Your Honor. For the record, Michael on behalf of the people.
Good morning, here to you on behalf of Mr. Hubert.
Okay, this is a follow-up hearing based on a delay of sentence that Mr. Hubert was placed on back in June. I did receive an updated report from probation, which is recommending his discharge. Mr. Rolla, anything on behalf of people?
No, Judge.
All right. Mr. Kilo?
Judge, I'd like you to strike the attorney fees because I am retained. Excuse me.
Got that. Mr. Hubert, anything you want to say? Okay. Again, I did have a chance to read the updated report. It appears that you've done everything that you were required to do, probably plus some on top of that in terms of your participation in AA and treatment, and that you've otherwise complied with everything. I reviewed the PSI, the original one, outlining kind of what happened, just to make myself more familiar again with your circumstances in this case. And I think you're absolutely entitled to the benefit of the bargain that you entered into. You've complied with everything. So the court will order that your previous OWI third charge be vacated, and that a charge of OWI second conviction by plea to OWI second be entered. The court will strike the attorney fees to the extent that that was ordered previously. Mr. Rolla, anything else that we need to address?
No, Your Honor, thank you.
Mr. Bilo?
Nothing further. Thank you.
Mr. Hubert, good luck to you going forward. I hope you stay on this path, and good luck going forward. Thank you.
Thank you, sir.
Versus Gisinger, case number 236670.
Your Honor, Michael on behalf of the people.
Here to you on behalf.
Sir, you can come right up. Thank you. And how do you pronounce your name, sir?
Gisinger.
Gisinger. Mr. Gisinger is present here in the courtroom today. Mr. Gilo, can you tell me where we're at with this file?
Judge, we're asking you for a 30-day adjournment. We're going to file a motion to attack some of the issues with respect to what he's being charged with and how he's being charged. If the court would allow us to do that.
Can you get that motion filed within that 30-day period?
Yes, yes,
Okay.
we've already prepared part of it, so it's not something that started.
Mr. Rolla, any objection or anything on behalf of the people?
No, Judge, it's a situation where the defendants allegedly one of a group of four that were basically just walking out with shopping carts full of merchandise. There was a plea offer of having it pled to without the habitual offender enhancement, which makes a significant difference. And again, I just indicate that for the record. Thank you.
All right, thank you. So the court will allow 30 days for defense to file any motions, and then we'll go from there. Mr. Gisinger, did you have any questions?
No, sir.
Okay, thank you. That's all for today.
Thank you, Judge.
Were you ready on Mr. Templeman's case?
I'd like to talk to him briefly.
We're about 10 minutes ahead, so we'll take a brief recess and we'll come back on the record at 9:15.
All rise, please.
Back on the record in Hill versus Troy, Allen Templeman, this is case number 195708. The record should reflect Mr. Templeman's presence here in the courtroom today. If I could have counsel put your appearances on.
For the record, Your Honor, Mike Roloff, the people.
Gary Gilo on behalf of Mr. Templeton.
Thank you. This is the date and time set for a sentencing hearing in this case. Mr. Templeman, have you had a chance to go through the pre-sentence report and talk to Mr. Gilo about that?
Yes, sir.
Mr. Gilo, are there any additions, deletions, or corrections to that report?
None, Your Honor.
Are there any challenges to the scoring of the guidelines?
No.
Mr. Rolla, do the people have any additions, deletions, or corrections?
Judge, the only, it's not an addition as much as it is perhaps an explanation, and I can deal with that in argument or how the court wants to do it. An issue got raised as to the situation with whether or not there would be credit for certain times, but case law, specifically People versus Prieskorn, PRIESKORN, 424 MISH 327 indicates that if people abscond, they don't get it. And that also, they cite Patterson, which is another previous case that held the same decision. I have a copy for the court to cover like to do it. I've shown it to Mr. Gilo and he's aware of that.
Okay. What is your position with regard to the amount of credit?
Well, again, if for matters that he had before.
Well, not necessarily your legal position, but how many days of credit?
Again, I don't have that number, quite frankly, Judge. It wasn't scored that way. I contacted probation school yesterday. I thought we were going to get a number. I don't know, perhaps Ms. Davis can perhaps provide that.
The PSI that I have indicates 51 days.
And I think that's correct.
Oh, okay. All right.
Okay,
What?
I thought you were disputing.
If he got the 50 days after he absconded, he's not entitled to it. He served it before he got his jail revoked, then I think under pre-scoring he's entitled to it. So it all depends on what happened.
So if that's what he's disputing, then he got 1 day jail credit for his initial arrest. Just 50 days jail time.
Okay.
And then he would be serving time on another offense, which he wouldn't get credit for in any case, Judge.
Okay. All right, Mr. Gilo, as to the jail credit issue.
Well, my client, looked at the history of my client. He has been he was in the Las Vegas jail for 1 year. He was in Macomb County Jail for several months. He's been in treatment. He went to the forensic center for several months. And then he has been in Otsego County. Without the so-called case that Mr. Rolla has indicated, we come up with 277 days credit. His bonds were all canceled on his incarceration. I've asked the court to take that into consideration in levying the sentence.
Okay. All right. I just want to make sure I'm clear. So Mr. Templeman was arrested on a warrant out of Otsego County and last year on December 20th. And then through today's date, that would be 50 days. And so wouldn't he be entitled to that? Because he was lodged in our jail on this charge.
On this charge, again, Judge, not the 200 and some days.
Sure, but the 50 days.
I think that again, as I read pre-scoring, that's what it says. He's not entitled to it unless, of course, he's serving a contempt of court charge. And if he's serving that for the 50 days, then he's not entitled to it because, of course, he's serving it on, not on this charge, but on contempt.
Okay. All right. Okay. Any other challenges to the scoring, Mr. Rolla?
No, Your Honor.
Anything on behalf of the people for allocution?
Judge, very briefly, the offense date in this case is from back in November 7th, 2018. We are talking 7th and 8th felonies, carrying concealed weapon, controlled substance, possession of cocaine less than 25 grams. The only reason, quite frankly, the prosecution wouldn't be requesting this court to send Mr. Templeman to the Michigan Department of Corrections is the age of the case. Thank you, Judge.
All right, thank you, Mr. Gilo.
Well, Judge, I just basically indicated to the court what I want the court to take into consideration, notwithstanding the fact we have the case law that Mr. Rowland has indicated to the court. Thank you.
Thank you, Mr. Templeman. Was there anything that you wanted to say today?
Your Honor, I was just to further what Mr. Gilo was saying. When we were in here in 2022, the PSI scored and put on record with the prosecution 277 days. The reason then we didn't proceed with court is because when I was housed in Macomb County Jail, when Larry Brown forfeited my bond so I could get the credit days served, was the 90 days. Then went for the competency review, which was another 90 some days, which would have came to 353 days. But if there's some absconding rule, I understand. But nevertheless, it was 353 days all in total, not 277. Take into consideration. Thank you.
All right. I did review the report, so I'm familiar with what happened in this particular case. There's also a lot of information in there about your background and your circumstances, Mr. Templeman. And, you know, this case has been pending for a long time, and there's various reasons for why it's taken so long for us to get a resolution. Your past record obviously is what it is. You've got a number of felonies that results in some higher guidelines for you, and as to these charges, it's 2 to 25. So the court would be within the guidelines to impose a prison sentence. Your previous history would suggest that might be appropriate. I think looking at the particular charges here, though, which the court's required to do, I don't think what you did in this case warrants a prison sentence. And I think some of the time that you have served, which I agree with Mr. Rolla in terms of the case law, that you wouldn't be entitled to credit for. But I think that is something the court can take into consideration in determining what the appropriate sentence is here. And all of that, again, together convinces me that a prison sentence is not appropriate. However, I think a jail sentence is appropriate. I think it would adequately provide a consequence to you for your behavior in this case, and also acknowledge your past history and the fact that you continue to engage in criminal conduct, even in light of past sanctions. So all of that being said, as to count 1, which is the concealed weapons charge, the court is going to follow the recommendation here. I think it's appropriate. It's within the middle of the guidelines. It calls for a community jail sanction. The court is going to sentence you to 7 months in the Otsego County Jail. The court is going to allow credit for 51 days. The court will order that you pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. As to count 3, which is the possession charge, the court will sentence you to 2 months in the Otsego County Jail, again with credit for 51 days served. Those sentences to be served concurrently, $68 state cost. You do have the ability to seek an appeal of the sentence, and Mr. Gilo, did you already provide those appellate rights, Mr. Templeman?
Yes, Judge, for the record, he signed them. I filed a receipt with the clerk.
All right, thank you. Mr. Rolla, anything further on this file today?
No, Judge, thank you.
Anything further?
No, Your Honor.
Thank you. Good luck to you going forward, Mr. Templeman.
Thank you.
Thank you. Mr. Trush, are you ready with one of your clients? On record in People versus Alexandria Davis. This is case number 246671. Record's right up here. Record should reflect Ms. Davis present here in the courtroom today. If I could have counsel put your appearances on.
Anna Brooker, appearing on behalf of people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Ms. Davis.
Mr. Trush, can you tell me where we're at with this file?
Yes, Your Honor. We're prepared to make admissions today. We'd be making an admission to count 1 as charged.
Ms. Davis, have you had a chance to talk to Mr. Trush about entering this plea today?
Yes, Your Honor.
Okay, and is that how you want to proceed?
Yes, Your Honor.
You can raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God.
Yes, Your Honor.
Thank you. Lower your hand. Ms. Davis, are you currently on any kind of probation or parole?
Not yet. No.
Okay. You understand that by pleading guilty to this charge, which is 3rd-degree child abuse, the maximum possible penalty that you could face would be up to 2 years and/or probation for a period of up to 5 years.
Yes, Your Honor.
With that in mind, what is your plea to that charge today?
Yes.
Okay. So right now, I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have a prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all of those rights,
Yes, Your Honor.
and you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Okay, also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask for the next higher court up, which is the Court of Appeals. You have to ask them to hear your case. They could say no, and that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything to get you?
No, Your Honor.
It's your own free choice to enter this plea.
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
So Mr. Trush, there's really no specific facts in the information here. Can you question your client to establish a factual basis?
Yes, sure. Ms. Davis, on the date in question, were you here in Otsego County?
Yes.
And you were here with your daughter?
Yes.
And what's your daughter's name?
Lily Davis.
And how old is your daughter?
She is 9.
And on that date, did you throw something in the direction of your daughter?
Yes, Your Honor.
Okay. And did that thing that you threw towards her, did it strike her?
Yes.
And even if that thing hadn't struck her, do you think a reasonable person would have been in fear or apprehension that they might have been struck by it?
Yes.
I think that probably provides everything the court would need.
All right, just, I mean, looking at the charge here, it indicates that there was some kind of physical harm.
Oh, and your daughter was injured by that?
Yes.
I don't have any other questions around.
All right. Brooker, are the people aware of any threats, promises, or inducements?
No, Your Honor.
Mr. Trush,
I'm aware of none.
Ms. Brooker, are the people satisfied that the court has complied with statute, court rule in the taking of this plea?
Yes, Your Honor.
Mr. Trush.
I'm satisfied, Your Honor.
Thank you. Ms. Davis, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date of that hearing. It's important that you stay in touch with Mr. Trush between now and then. Before you leave here today, you're going to meet with Ms. Davis from Probation.
Okay.
And she's going to set up a pre-sentence interview with you. Okay. Thank you.
Thank you, sir.
And Your Honor, I just wanted to make the court and embassy aware there is an open CPS case as well. And we expect that we're going to have a psychological evaluation from that case, which we very likely are going to be providing to the department and the court.
Okay, if that's gonna require a delay in sentencing or something, just let us know and we can, no.
And we expect to have it this Friday.
Oh, okay,
We expect to have it soon.
okay, great, all right, thank you.
Your Honor, I know that we're a little bit ahead. Mr. Renay and Ms. Bynum are both lodged. They did both request to be brought over as opposed to Polycom. I know all I can do is ask them.
Is there a reason why they're asking for that?
Mr. Renay specifically has indicated he would very much like to look you in the eye as he explains what happened. Frankly, I think Ms. Bynum would just be more comfortable if she's able to actually stand next to him.
I'm not seeing.
I don't see
Renay
Rental.
on
Yeah, 9:45.
And I would indicate, Your Honor, I think Ms. Ventline scheduled this while Ms. O'Rourke was out of the office, and it was, I want to say Thursday or Friday of last week.
You have it on yours?
Yeah, but you got the docket I gave
This
you.
is the old one. huh?
Well, where's the one I gave you?
What is the nature of the hearing?
He was arrested on a bench warrant for failure to appear.
Thank you.
Oh,
And I would indicate he intends to make admissions in the underlying case today.
Mr. Williams.
He's out in the lobby, usually to talk to. So are we gonna have Miss Bynum and Rental?
No, I mean, I've got a lot of. I'm gonna have both of them appear by Polycom, Mr. Trush for security reasons. It's the policy of the court not to transport individuals unless they have a specific right to be in the courtroom for security purposes. So.
Understood, and I advised them that that was a very possible answer we would get.
Sure, okay. All right, so let's take a short recess. We'll get those two available by Polycom. If you can speak with Mr. Williams, and then we'll get started again in about 5 minutes.
All right, what? Yeah.
We're on the record in People versus Jesse Williams, case number 246673. The record should reflect Mr. Williams is present here in the courtroom today.
Record gentleman, I call on behalf of the people.
Thank you, Your Honor. Richard Church, appearing on behalf of Mr. Williams.
Okay, how do we want to proceed in Mr. Williams' case, Mr. Church?
Your Honor, we're going to be asking for a adjournment. I would ask for 30 to 60 days, however the court feels appropriate. We are looking to put together some of Mr. Williams' mental health records to provide to both the prosecutor and the court. And then we expect that we're likely going to be in a position to either have a agreement for the court or ask that the matter be set for a trial. And I would indicate Mr. Williams has already provided me some of the records today.
Okay, Mr. Roloff?
The judge, we're talking about an offense date relatively recently, December of 2023, so people don't have any objection.
All right, and before we know, this is Mr. Williams' first appearance before the circuit court. Realistically, Mr. Trush, how much time do you think? I just don't want to set it and then have to adjourn again, so.
So I think 30 days would be fine, but if the court were inclined to do 60, I mean, I don't think more time would hurt us.
Okay,
And again, given the recentness of the case.
all right. Mr. Williams, do you have any objections to this delay?
No, I don't.
Okay, all right, so the court will set it for a status conference plea hearing at about 60 days. So with that extra time, Mr. Trush, the court will order that that be a plea cutoff date. So if we're gonna have an agreement, we would need to enter into it at that time.
Understood. And I have already discussed with my client that we expect to come back with an answer for the court.
Okay, thank you. Mr. Rolla, anything further today on this file?
No, Judge, thank you.
Mr. Church.
No, thank you.
Thank you, Mr. Williams. Just make sure that you stay in touch with your lawyer, okay?
Same kid no more.
All right, sir, is your name Daniel Renay?
Yes, sir. Good morning, sir.
Morning. We're on the record in People versus Daniel Renay. This is case number 236505. The record should reflect Mr. Renay is appearing today by video from Otsego County Jail. If I could have counsel put your appearances on.
Thank you, Judge, for the record, I call on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Renay.
All right, we're on the record today for a status conference, and then Mr. Renay's bond was revoked back in October for failure to appear on October 4th. He was recently apprehended, so he's lodged without bond at this time based on that failure to appear. So Mr. Trush, how did we want to proceed today?
So, Your Honor, there's two things that I would like to do today. One, I think we have an agreement that Mr. Renay is going to enter into to resolve the case. And secondly, I would like to address the non-appearance in the bond to the court.
Okay. Let's address the bond issue first. So Mr. Renay, and just going through the file, I mean, he failed to appear back in April, and then again, obviously in October. So what are you requesting with regard to bond on that?
Well, so I guess I'd like to start by addressing, in April, he did fail to appear. The court may recall he had contacted me at that failure to appear. He was stuck in an appointment with his wife who has a brain issue, a significant brain injury. He was at an appointment with his wife and just was not able to log in. The court did graciously set a show cause, not a warrant at that hearing. We provided information to the court to support where he was and why he was not here for that April hearing. And so far as the October hearing, actually I had communication with his wife. She has an app on her phone where she gets notification of every piece of mail that is delivered to their home, which is actually very useful in trying to determine what happened here. And in fact, she did receive notice of this. We were able to identify the notice went out on July 17th. I think she received it on either the 18th or the 19th. The problematic thing is she received it when Mr. Renay was not there. Mr. Renay didn't get it. His phone was disconnected. And basically, when he was in Traverse City and found out that's when he found out there was a warrant. I would indicate to the court, I have discussed with Mr. Renay how to troubleshoot that issue in the future, which is to say, again, we intend to resolve the case today. I've indicated to him if he does that, his sentencing date is going to be in the first week of March. I've indicated to him if he doesn't receive a notice, he needs to contact me prior to that to make sure that he knows when it is. He's made arrangements with his parents to be able to be have transportation from Traverse City to the courthouse. So I mean, I think that we've troubleshot the issue as much as is possible to ensure his appearance here. I know he is very, very sorry for what happened, and frankly is very gracious for how the court has given him leeway in regards to his wife's brain issue. The last thing I would indicate is his wife sent me a copy of basically she carries a card with her everywhere that identifies what her brain issue is and the symptoms of it. And it identifies a variety of things, including difficulty with attention, concentration, memory, understanding. So again, I mean, we acknowledge that this notice was sent out on July 17th for the October 14th date. She did ultimately receive that. It didn't get from her to Mr. Renay. And unfortunately, with his phone cut off, I didn't have any way to contact him. And I believe Mr. Renay is going to echo a lot of the same sentiments when asking the court to consider reinstating the bond and allowing him to be out after the plea pending the sentencing. I would just indicate additionally, I think in support of that, we know that while his guidelines are going to be such that there's a presumption against jail, it's not an impossibility. And I do think he wants to try to make arrangements to make sure that his wife is taken care of in the event that he does have to serve some jail, because she really can't be living independently.
All right, thank you. Mr. Rolla, as to the bond issue, if you can take any position.
Well, Judge, it's not one, it's actually two failures to appear as the court is well aware. And even as the motion hearing, which this court had, the defendant also failed to appear for that court because indicated by his failure of appearance, he waived his having ability to appear for that hearing. Now, as far as what the court's going to do for the failure to appear, I guess the people have two different positions depending on the factual circumstances. As Mr. Trish is indicating his client's going to be entering a plea today, then of course people aren't as concerned after a plea is entered that the court may want to give some allowance. Obviously, that's within the discretion of the court. If this is not going to have that way, then I think we're dealing with a different circumstance. Thank you, Judge.
All right, thank you. All right, Mr. Renay, is it your intent to enter into a plea today?
Yes, sir, it is.
Okay, Mr. Trush, can you tell me the terms of the plea agreement?
So, Your Honor, I'm going to receive an offer from the prosecutor where he would plead counts 1, the possession of, I believe it's methadone, and count 3, the DWLS. I did ask the prosecutor to consider allowing him to plead to allowing a suspended person to operate as opposed to the DWLS. I don't think he was opposed to that. Functionally speaking, Mr. Renay is able to apply for a license again in 4 years. If he's convicted of the DWLS, it's going to kick it out to 9. I mean, that's the consideration there.
All right,
Anyway, people don't have any objection as long as he's entering a plea to count 1. Then the other count would be actually added count 5, Judge, allowing a suspended person to operate.
Okay, so count 1 is the possession of cocaine.
Correct.
Okay.
And then there would
I think it's actually
a
alleged.
dismissal of counts 2, 3, and 4, but also plea to added count 5.
All right, and what about the enhancements?
Well, the enhancements were, I believe, being dismissed according to the plea offer I see in the file by Mr. Fenton in our office. He indicated that for the file. Okay.
All right, so count 1 and added count 5 of allowing someone to operate.
Correct, Judge. I'll give the court the cite on that in a moment.
Okay.
And the only other correction I would make is at least that information that I have says, controlled substance possession, but the substance that's listed on mine is methadone, not cocaine.
And Your Honor, for the court's information, it would be MCL 257.9042A. And I'll write it for the clerk in a moment.
Your Honor, I apologize. There's an amended that changes it to cocaine.
All right, Mr. Renay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, thank you. You can lower your hand. So, Mr. Renay, under the plea agreement, you would be pleading guilty to count 1, which is possession of cocaine. That carries with it a maximum possible penalty of up to 4 years and or a $25,000 fine. And then you would be pleading guilty to an added count 5 of allowing a person with a suspended license to operate, and that is a 93-day misdemeanor. All the other charges and enhancements would be dismissed. Do you want to proceed with that plea agreement today?
Yes, sir, I do. Again, with my apologies to the court for missing that date.
Okay. Are you currently on any kind of probation or parole?
No, sir, I am not. I have not been in any trouble in over 10 years. Since my last trouble, I've gotten married. I own a business. I'm just trying to take care of my wife and my family. My parents are not in good health. I missed the court date. I'm not going to make an excuse that I didn't or didn't get a letter. I know it showed up at my house as of late. That's all that I
Mr.
know.
Renay. Mr. Renay, slow down. We're gonna talk about that in a minute. This is the plea
Okay.
right now.
Okay, I apologize. Just nervous.
Okay.
That's all right. That's all right. Do you understand those maximum penalties for the 2 charges that you're going to be pleading guilty to today?
Yes, sir, I do.
Okay. And then with those maximum possible penalties in mind, what is your plea to each of those charges?
Guilty on both charges, sir.
All right. Right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, sir, I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, sir, I do.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir, it is. I just want to get this over with.
All right. Are you pleading guilty because you are guilty?
Yes, sir.
All right. So this incident happened back on February 18th of 2023. Is that correct?
Yes, sir.
Okay. And on that date, you had a traffic stop by the Otsego County deputies. Did that happen here in Otsego County somewhere?
Yes, sir, I believe it did.
At that time, were you in possession of some cocaine?
Yes, sir, I was.
And did you know that that's what that substance was?
Yes, sir, I did.
Did you have any legal right to have any amount of that substance at that time?
No, sir, I did not.
Okay, and were you operating that?
Yes, sir.
That was on Meridian Line Road here in Otsego County?
That sounds correct, sir. Yes.
All right, and at the time you were operating that vehicle, was your driver's license suspended or revoked?
Yes, sir, it was.
Mr. Rolla, are you satisfied with the factual basis?
Yes, Judge, court's taking the plea to the added count 5 using the basis of driving license suspended. We feel the court's complying with court rule statute. As to acceptance of pleas, and we're aware of no threats or promises not placed on the record. Thank you.
Mr. Trish.
Likewise, Your Honor, I think the court has complied with court rule. I'm satisfied that there is a sufficient factual basis, and I'm aware of no threats, promises, or inducements.
All right. Mr. Renay, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. The court is going to reinstate your bond. You were arrested on the bench warrant on January 31st, so you spent about 8 days in jail. I think that's a sufficient penalty for violating your bond, and I think that that's also sufficient to impress upon you the importance of appearing at future hearings. So the court will reinstate the previous bond. And you will be released today. The court will set this for a sentencing hearing. Ms. Davis, are you going to contact him while he's still there at jail, or how do you want?
We're not, but if you could update us with a video phone number, then we can reach out to him and schedule it.
All right, Mr. Renay, we need a current phone number from you because somebody from the probation department is going to contact you for a pre-sentence report.
Sure. Are you ready?
Yeah, go ahead.
231-645-9476. And I would like to change my mailing address to my parents' address as well. So if something shows up, they will bring it to me immediately so I don't have it happen again.
Okay, yep, go right ahead.
844 Avenue E as in Edward, Traverse City, Michigan, 49685.
Okay, thank you. And then you need to make sure that you stay in touch with Mr. Trush over the next 30 days, okay?
That is not a problem. I now have his number committed to memory. I apologize to the courts. I was not trying to waste your time, and thank you for your consideration.
Okay, all right, Mr. Trush.
So, Mr. Renay, remember, we expect the first week in March. So if you do not receive that notice, call me.
I'll be on the phone with you once a week just to make sure everything's up and up.
That works for me.
Oh, yeah,
That was the other question I have is, do I need to prepare an order?
yeah, please do that and I'll sign that. I can sign that as soon as you get it over here.
So, Mr. Renay, we do have to provide an order to the court. My guess is likely tomorrow morning, everything will be in place, okay?
I'm sorry. So I guess I don't understand what you're saying. Am I released today?
So,
My
so
father
he
should
has-
be here in a half hour.
So just like we talked about last night, once the judge orders it, we have to provide the order. It's got to get from me to the prosecutor, to the judge, and then over to the jail. I'll get it done as quick as I possibly can, but just understand that process has to happen.
Okay. So
If you want to just send it by email, I'll get the blast form. That way you get it to them quicker.
All right, thank you. Then if we could have Ms. Bynum, please.
you bet, sir. I'll be right with you. Thank you, Your Honor. Yeah.
step up there, let me close the door and you can go to the back, back up to the door. There you go.
All right, ma'am, is your name Erica Bham?
Yes, sir.
All right, we're on the record in People versus Erica Bham. This is case number 246675. The record should reflect Ms. Bynum's appearing today by video from Otsego County Jail. If I could have counsel put your appearances on.
For the record, John, my on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Ms. Bynum.
All right, we're set for a scheduling conference in this case today. Can you tell me how you want to proceed, Mr. Church?
Yes, Your Honor. Two things that we'd like to try to achieve today. We are going to be accepting an offer. The prosecutor has made an offer whereby if Ms. Bynum tendered a plea to count 1, the possession of methamphetamine, count 2, as well as the habitual offender notice would be dismissed. She intends to take advantage of that today. I also would like to address bond to the court in regards to this matter.
Okay, let's go through the plea first. Mr. Rolla, is that a correct statement?
I believe that's correct, Judge.
All right. Ms. Bynum, have you had a adequate opportunity to speak with Mr. Trush about this plea agreement?
Yes, Your Honor.
Is that how you want to proceed today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Ms. Bynum, are you currently on any kind of probation or parole?
No, sir, I'm not.
All right, you understand that the maximum possible penalty that you could face for possession of methamphetamine would be up to 10 years and or a $15,000 fine?
Yes, sir, I do.
With that maximum possible penalty in mind, what is your plea to that charge today?
I plead guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the next higher court up, which is the Court of Appeals. You have to ask them to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, sir, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir, it is.
Are you pleading guilty because you are guilty?
Yes, sir.
The information I have indicates this happened on December 12th of 2023. Is that the correct date?
Yes, sir, it is.
On that date, were you present here in Otsego County?
Yes, sir, I was.
On that date, while you were here in Otsego County, did you have possession of some methamphetamine?
Yes, sir, I did.
Were you aware that that's what that substance was?
Yes, sir.
Did you have any legal right to be in possession of any amount of that at that time?
No, sir, I wasn't.
All right, thank you. Mr. Rolla, are the people satisfied with the factual basis?
People are satisfied with the sufficient factual basis to accept the defendant's guilty plea as to count 1.
Mr. Church.
Defense is satisfied.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on it?
No, Judge, and the people are satisfied with the statute as to accept.
where no threats, promises, or inducements, and defense is satisfied the court has complied with court rule.
Thank you. Ms. Bynum, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. In terms of the bond request, Mr. Trush.
So, Your Honor, the information I have currently shows that the bond is set, I believe, at 10,000 cash or surety. Our request would be that the court consider setting it at 10,000, 10%. A few things I want to bring to the court's attention. One, the address listed on the complaint is inaccurate. Ms. Bynum does not live in Texas. She had been residing, I believe, in the Lansing area for some time before this incident happened. At present, she has secured housing here in Otsego County until this matter is completed. So she does have local housing that she can go to. She's also secured work if she's released. And I would indicate sort of at a fundamental level, I think she needs a higher quantum of mental health care than is available to her and she's getting into jail. She's already made contact with community mental health as well as Catholic Human Services to try to make sure that she has the appropriate supports if she were to be released. I would indicate she's been in for about 60 days. I think there's a reasonably high probability that she's looking at a time served type sentence, given the nature of the charge and what her guidelines are likely to be.
Thank you, Mr. Rolla.
Well, Judge, obviously, I can't speak to why the defendant didn't have a Michigan residence or license. Obviously, if she's moved to Michigan from Texas, which she apparently has, she has the obligation of either getting a Michigan ID card or a driver's license. That's on her. That's not on the court. That's not on the people. I'd also advise the court that according to her history, she has a Texas record that involved jumping bail in April 21st of 2007, possession of controlled substances under 2 ounces in August 4th of 2017, and an assault with a dangerous weapon contra Texas statute PC 2202A2 out of the 35th Judicial District Court, Brownwood, Texas, in February 28, 2018. So I don't know if she's not even willing to update her driver's license. I don't know what assurances the court can have that she's going to appear here as requested. Obviously, that's to the discretion of the court.
All right.
I do want to address a few of those things if I can. So the situation in Texas is actually somewhat unique. She absolutely was charged with and ultimately convicted of and again, I think it's assault with a deadly weapon or aggravated assault with a deadly weapon. The conviction actually happened, I believe, in 2007, not in 2018. The reason the abstract looks the way it does is she was on a 10-year essentially diversion on that. She did violate by failing to report to probation. That's what triggered the violation in 2018. She was in complete compliance for 9 years. It's that was the event that triggered that. That's the bond jumping, was she had a single failure to report to probation, and that triggered all that. So I think that is relevant. And as far as the address, I'm not suggesting that the court was wrong or the prosecutor was wrong. I'm just saying that to indicate to the court on its face, if the court looked at that and saw she lives in Texas, I think the court would have significant concerns about release, but it's just not accurate.
All right. I did have a chance to review the file as we were going through the plea. The bail was initially set at $20,000. It was reduced by Judge Cooper to $10,000. Number one, Ms. Bynum, now that we have a plea entered, doesn't have the right to pretrial release any longer under the court rules. I'm not convinced, maybe she does have a local address or somewhere local that she's staying. I'm not convinced that her ties with Michigan are strong enough that having a local address, particularly in light of the fact that apparently none of her documentation's been changed from Texas, satisfies me that she has sufficient ties to our community to ensure that she wouldn't return to Texas to avoid sentencing. So for those reasons, the court finds that the bond is appropriately set. Request a modified bond we'll set this matter for sentencing at the court's next available date. And Ms. Bynum, somebody from the probation department will be in touch with you there at the jail to prepare a pre-sentence report. You'll have a chance to speak with Mr. Cruz, your lawyer, about that prior to sentencing. And we'll go forward from there. Mr. Rolla, anything further on the record here today?
No, Judge, thank you.
Mr. Truce?
Just one thing briefly, I would indicate, and I already communicated this to the Department of Corrections. I would like to be involved in the pre-sentence interview. I think there is some case law that supports that I can do that if I want to. In this particular case, I think it would be beneficial and important. So I am just requesting that I be included in the PSI process.
Okay, so Ms. Davis, whoever's going to do that, if you can note that, to let Mr. Truce know. Okay,
What's
thank
our
you.
address?
All right, that's all for today. We're going to disconnect from the jail at this time.
Thank you, sir.
Thank you, Your Honor.
Mr. Blumberg, were you ready on Mr. Swift's case? Okay. We're on the record now in People versus Randall Swift, case number 2336. You can go over to voting, please. Yep. If I could have counsel for your appearances on.
Thank you, for the record, my phone, we have people.
Good morning, Judge Elliott Blumberg on behalf of Mr. Swift.
Okay, thank you. The court noticed this up following the sentencing hearing last month because of a challenge that we had to OB5, and the court had granted the prosecutor's challenge to OB5 in terms of it had been scored at 0, and so the court rescored that at 15. I later had an opportunity to revisit OB5, and it's my view that I was in error when you look at OB5. And when I analyze that for purposes of the sentencing hearing, I look at from the standpoint of, okay, this is a crime against a person, so OB5 should be scoreable, but the statute governing OB5 indicates that OB5 is only scored for crimes against a person and only if the sentencing offense, the homicide, an attempted homicide, or conspiracy, or solicitation in a homicide, which the conviction in this case was not to any of those charges. So I'll hear from counsel, but in my view, I think the court did incorrectly score OB5 at 15 points.
Yes, Judge, in regards to the court's comments, and again, my comments are not in any way attempted to be disingenuous in any way with the court. But as to it being a homicide, the court's well aware for the purposes of the sentencing guidelines, any incident that results in a death is considered a homicide. And this, as the court's well aware, was a circumstance originally of reckless driving causing death. That's what led to this matter. So in the people's position, it is a homicide situation, and we think that OB5 should have been scored and was properly, not in originally scored in the PSR, but should have been properly scored as 15 points. Thank you, Judge.
Mr. Blumberg.
Judge, I think the court's analysis is accurate. We would simply ask the court to correct the scoring as the court apparently feels is appropriate.
Okay, so again, the statute refers to the sentencing offense, while the charge did involve reckless driving causing death. That wasn't the sentencing offense. So the court finds that as the sentencing offense did not involve a homicide, that OB5 was not properly scored. So the court is going to order that OB5 be scored at 0 points. I don't believe that scoring affects the upper end of the guidelines. It does lower the lower end. I indicated for purposes of setting this hearing that the court did not intend to change the sentence imposed in any way, but merely the purpose was to simply hear from counsel and to rescore. Mr. Rolla, anything else that you wanted to do?
No, Judge, thank you.
Mr. Blumberg.
If the court would indulge me, I feel at least an obligation to report to the court what has transpired since the date of sentencing and my client's incarceration. The court was obviously made aware of his health concerns and many of the health issues that he faces. He has already been taken once to the emergency room because of
his immune system being weakened because of his cancer. He did contract MRSA, and I am been made aware, I've been down there a couple of times, that he's not receiving the medications at the times that he is required to take them from his medical professionals. I'm greatly concerned, and I don't mean to cast aspersions to the jail staff. I know they've got a bunch of people they have to attend to. My concerns are very serious concerns about Mr. Swift dying while he's in jail. So I'm trying to put together a new motion for the court to reconsider the facts, but before that can be heard, I just want the court to be aware of what's going on. This gentleman is likely to pass away unless he's attended to, at least according to the doctor's directions. So,
Okay.
thank you.
And I did, I did state at sentencing that I would allow furloughs for medical treatment and even long-term furloughs to the extent that it was necessary. I communicated that directly to Captain Weber at the jail and indicated to him that if it got to the point where we needed to have a house arrest situation because the jail wasn't adequately able to take care of Mr. Swift's health concerns, that I was approving that ahead of time.
I appreciate that, Judge.
So,
And he has been allowed to go to his doctor's appointments. He's just, I know, a sick guy that's got health issues. So anyways, I appreciate the court listening to me today in regard to this.
Thank you.
all right, okay, thank you.
So 3 times a week, I don't see it forever.
I know.
Yeah. Okay, our next hearing set for 10:45, so we'll take a recess until that time. Okay, we're on the record in People versus Jarr and Orman, case number 236658. The record should reflect Mr. Orman's present here in the courtroom today. If I could have both counsel.
For the record, Your Honor, Mike Rowland on behalf of the people.
Just look on behalf of Mr. Orman, who is also present.
Thank you. This is the date and time set for a sentencing hearing in this case. Mr. Orman, have you had a chance to go through the pre-sentence report and talk to Mr. Slocum about that?
Yes, sir.
Mr. Slocum, are there any additions, deletions, or corrections that need to be made to that report?
Yes, just very briefly to the PSI. On the very first section, the basic information report, it talks about mental health treatment, and it says no. My client, since high school, has been a senior counselor, is currently counseling with Catholic Human Services. Very minor thing, but just a slight correction.
Mr. Rolla, any objection to adding that information?
No, Judge.
Okay, so we'll change on the basic information report, mental health treatment to yes. And you want to add in the narrative portion under the health where there's some information under mental health there. Did you want to add that he's currently
Counseling with Catholic Human Services.
okay? So we'll add that he's currently under counseling with Catholic Services. Okay, any other changes?
Not to the PSI. We have a one, I guess, objection on sentencing guidelines.
Okay, what's that?
In relation to the offense variables, my client was assessed 10 points for OB 18.
Okay.
That's obviously that's in relation to a drunk driving. Shouldn't apply here.
Okay, Mr. Rowland.
Judge, the objection is as to scoring as to which?
OB 18 is currently scored at 10 points.
And the defense argument is that that should not be scored at 10 points
Correct.
because
It doesn't involve the operation of a motor vehicle under the influence of alcohol or drugs.
correct.
Okay. So the court will order that OB 18 be scored at 0. That would result in a reduction of the OB score to 0 and OB level to 1. Let's see, what does that change the guidelines to?
I believe 0 to, just double checking, 0 to 6 months.
0 to 6. Okay, so the court will order that if the guidelines be rescored at 0 to 6. Any other changes?
No other changes, Your Honor.
Thank you. Mr. Rolla, any additions, deletions, or corrections?
No, Judge, thank you.
Any challenges to the guidelines?
No other than what's already been addressed on the record.
Anything on behalf of the people for allocation today?
Briefly, Judge. As the court is well aware and is reflected in the PSR, this is a situation where the defendant decided on his own that he was going to smuggle both controlled substances and tobacco products to the jail. 62 Adderall pills and 53 nicotine pouches so he could make his stay in the facility easier, apparently. There is a recommendation here, and again, there was recommendation 9 months on the base, so it would be 6 months if that's what the guidelines are. In any case, saying that it should be held in abeyance, I don't believe that that's an appropriate circumstance because I think it delivers a very wrong message. Now, whether or not the defendant was bringing these items into the jail to make it easier for himself, whether he was bringing it to bring it into the jail to pass out to other inmates, sell to other inmates, whatever the case might be. Doesn't matter, but that still creates a dangerous situation for correctional facilities. So I don't believe that having him get no jail time or effectively 2 days with the 2 days credit is appropriate sentence. Thank you, Judge.
Thank you, Mr. Sullivan.
Just to briefly address what the prosecutor was saying about, possibly bringing these in for other people. As a metaphor, if you're going to smuggle something, you would have something with the highest currency. He was bringing an Adderall. If he was going to bring in for other people and to have the greatest advantage in jail, I would submit to the court, you'd probably be in fentanyl or heroin or something like that. My client was obviously addicted to Adderall, and he was in a very bad place when this started. It was not. These are drugs that were prescribed to him. It was something that he was abusing. I mean, it was prescribed, and he was using the amount that was prescribed to him. But the jail didn't allow Adderall to be used, even if it is a valid prescription. And that's certainly within the purview of the sheriff's department. We understand that, and my client certainly understands that. He since has weaned himself off of Adderall, has not taken any at all. There is a statement that he did poorly on the sobriety court probation, and that probably wasn't the best fit for him because it wasn't that he was using, it's just that he was not able to make it to the appointments. Since that time, since the 35 days that he has served, the 35 days came after this incident. I'm not suggesting to the court that he get credit for that time served. I'm suggesting that it had an incredible effect on my client. He never wants to go to jail again. He has been a successful person on probation since that time. He has continued with counseling, both for drugs and alcohol and also for mental health issues. The court can see that the way that he grew up is not something that a normal person should have to deal with. I mean, his biological father was out of the picture. His adoptive father was somebody who used crack cocaine and had been in and out of prison. I think my client has done extremely well. He has a profession. He's a hairstylist, and from what I understand, that he is quite good at it, and his clients love him. I know the one of the four aspects that the prosecutor is talking about, that we want to send a message that he should be getting jail time for this, and I do understand that, but all the other factors overwhelmingly say that that the court should follow the recommendations of the probation officer, that this should be held in advance. He has definitely learned his lesson. He is definitely aware that he now has a felony, and that is certainly a punishment in and of itself that he will have to deal with. And he also does take care of his brother, who is disabled, who is schizophrenic, and if he is not there, somebody has to go on a daily basis to take care of him. But the point of this is that, and I'm not trying to downplay what he did. It was certainly wrong, but it wasn't the drugs that he was smuggling in, Adderall and tobacco patches, were just to help him try and get through the time. And he realizes now that that was completely inappropriate. I have seen an amazing amount of remorse in him, and he is a good kid, quite likable, and I don't think he's going to be a problem for the justice system at all. I think he'll be a productive member of society going forward. Thank you.
All right, thank you. Mr. Orman, anything you wanted to say?
I'm glad we addressed the counseling there, because I forgot to mention that in my personal letter to the courts. Everything I said in that letter came from the heart. I genuinely am accepting the consequences for my actions. I've had a lot of time to think about it and to talk to people and to prepare as best as I can. I want everyone that I've been dragging through the mud with me, who care about me, to stop having to worry so much. And I just want to be done with it. I just want it to be over and I want to stop. Making decisions that lead me to results like this. And that's all I have to say.
All right, thank you. I did have a chance to review the report, so I'm familiar with what happened in the circumstance while you're before the court on this charge. I also went through all the background information in your statement that was provided to the court. And taking all of those things into consideration, number one, I do think the recommendation for probation is appropriate. I think some supervision over the next year, make sure that you're staying on the right track is a good thing to provide some accountability for you as we go forward. In terms of a jail sentence, I do agree with the prosecutor. This is the kind of circumstance, and I don't necessarily think that you were gonna, trade or sell these things in the jail. It does appear to me that you were bringing that in for personal use, but bringing outside substances, and neither of these things is particularly dangerous in terms of the risk of overdose or death. But bringing any kind of substance into a controlled environment like that is inherently dangerous, and not only for you, but dangerous to other inmates. People find out that you got that. I mean, they may want some of it. If you don't want to give it to them, they might find a way to get it from you, which is dangerous to you. It presents a danger to the staff that are working there. There's just many, many reasons why the court needs to deter this kind of crime in particular, because it does possess. We have overdose deaths in the jail from time to time. People bringing other substances which are more dangerous in the jail. So the desire for deterrence is, I think, a major consideration in your sentence. However, if you're gainfully employed, I think I don't have any objection to you being released to the work camp as you serve out the jail time. I think 90 days is an appropriate sentence, provides a degree of consequence and punishment for you for bringing those substances in. It provides hopefully a measure of deterrence, so people know if they're going to bring anything in, whether it's for personal use or for sale, whether it's an inherently dangerous drug or something just to manage your time in there, that's just not acceptable, and that it's going to be met with punishment. So the court is going to place you on probation for a period of 12 months. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to order that you serve 6 months in the Otsego County Jail with 90 days, the first 3 months up front. The court will hold the second 3 months in abeyance. I don't have an objection to your release to work camp immediately on the first 90-day part of it. The court is going to order a crime victims assessment of $130, a court cost of $325, a DNA testing fee of $60, a $68 state cost, and supervision fee of $30 per month while you're on probation. You do have the ability to request an appeal of this sentence. Mr. Slover is going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with the appeal. You do have credit for 2 days served. No, he's going. I don't have an objection to release.
Okay.
He needs to go. We could beat that in. Mr. Slocum has Mr. Orman received his appellate.
Yes, Your Honor, and acknowledge receipt of that, and we return the initial copy to the person.
All right, thank you. Mr. Orman, we're going to go with the officer at this time. Mr. Brown, are you able to hear me okay?
Yes, I am. Judge. Thank you.
All right, Mr. Wilson is connecting. I'm just waiting for that connection to go through, so just 1 second.
Hi.
Mr. Wilson, are you able to hear us?
Can you guys hear me?
Yep, can you hear me?
Hear you. Yes, sir. My camera says it's working. Can you guys see me at all?
I can't see you, but let's try to go forward here. If
Yes,
you can get
sir.
that work, that's great. We'll go on the record in People versus Michael Wilson. This is case number 216196. The record should reflect Mr. Wilson's present today by video. Mr. Brown is present by Zoom video on behalf of Mr. Wilson. We have Ms. Davis on behalf of probation and Mr. Rolla on behalf of the people. This is set for a probation violation hearing today. Mr. Brown, how did we want to proceed today on behalf of defense?
Hey, Your Honor, it is my understanding there was an underlying OWI charge to which Mr. Wilson had previously pled to, was admitted into drug court in Ohio from where he is now appearing. As far as this probation violation goes, we are going to enter a plea.
Your Honor, if I could
Sure.
interject, Agent Leo, because he was accepted into the military veterans court in Ohio, he was going to ask that this probation violation be dismissed at this time.
Okay, Mr. Brown, were you able to hear that?
I was, Your Honor, and I definitely do not have an objection.
Okay, so is Mr. Wilson still participating in that?
Yes, he is, Your Honor.
All right, so Mr. Wilson, the probation department here is going to defer to your Veterans Treatment Court program, and they're going to dismiss the probation violation in this case, okay?
Yes, sir. Thank you.
So you need to continue, number one, to continue participating in and complying with all the conditions of that treatment court program there. And you also need to make sure that you continue to report as ordered to your probation agent here, okay?
In Michigan, Judge? Is that?
In Ohio.
Or in Ohio, I'm sorry.
Oh, okay. Okay. I was like, I wasn't aware of contact info, so I was gonna try to get that.
Yeah, okay. All right, did you have any questions, Mr. Wilson?
No, sir. Thank you so much.
Okay, thank you. That's all for today. All parties in this case are free to disconnect at this time.
Thank you.
Oh, hey, there I am.
Okay, next hearing set for 11:15 with Mr. Evans. Once we have everybody connected, we'll get started on that.
Oh, Richard asked if I could send him a global offer. I'm looking at both final stuff, so. Yes, I never seen that.
for tonight.
And there, in Alpena, we're looking for Mr. Evans.
We'll be right back with them.
All right, thank you. All right, Mr. Evans, are you able to hear me okay?
Yes, Your Honor.
All right, thank you. We're on the record in People versus Jason Evans. This is case number 236554. The record should reflect Mr. Evans is appearing today by video from Alpena County Jail. If I could have counsel put your appearances on.
For the record, Your Honor, Mike on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing for William Pfeiffer on behalf of Mr. Evans.
Okay, my understanding, Mr. Trush, maybe you can just give us an update on where things are at in terms of Mr. Evans' counsel.
So I'd be happy to let the court know as much as I do. At this point, I don't claim to know a lot. Mr. Gilo's office contacted me yesterday and asked me if I'd be willing to take Mr. Evans' case on in my caseload because Mr. Pfeiffer was filing or planning to withdraw from the case. I don't know the circumstances behind the withdrawal, if it's financial or some other breakdown or what the issue is there. My understanding from Mr. Gilo was that there were not yet trial dates set, although I have been informed this morning that not only are trial dates set, but I think they are impending very quickly. I would indicate, frankly, I don't know if that necessarily changes my position in terms of if an attorney needs to be assigned to it. I have Mr. Evans on other cases and I'm willing to take it. I do have significant reservations about my ability to be prepared for a trial in, I think, about 2 weeks or 3 weeks time, having no information on it to this point.
Okay. Mr. Evans, can you tell us, are you still retaining Mr. Pfeiffer? He hasn't appeared today. What's your status with Mr. Pfeiffer?
I received a text from him this morning telling me that when my father retained him, he retained him for the circuit court up till trial, but further funds were required for trial, and my father no longer had further funds, so Mr. Truce was going to be handling the case. And
okay,
that's all I know.
All right, if Mr. Pfeiffer withdraws or files a motion to withdraw, are you going to be requesting court-appointed counsel, or are you going to try to hire your own attorney?
No, I would need court-appointed counsel. I have no funds to hire an attorney. My father hired Mr. Pfeiffer, and I guess he doesn't have any more funds for a lawyer, so I would need court-appointed counsel.
Okay.
And my understanding, Mr. Pfeiffer did reach out to me this morning and said he was preparing a substitution. So I don't know if that's maybe come into my office while I've been here in court. But.
Okay, Mr. Rowland.
Judge, I would agree that we have the matter scheduled to start on a multi-day jury trial starting on February 26th. We have 18 people subpoenaed, including 3 or 4 separate lab personnel. So there are quite a few individuals that we have subpoenas out. I'd also advise the court, there's another trial that's scheduled to overlap this, and the Evans trial we also have. If you give me a minute, I'll pull it up.
That's okay, I know.
But anyway, so if the Evans trial can't go, I want to let the court know we have subpoenas out for the other trial as well, just in case that, because our office was advised yesterday afternoon by Mr. Pfeiffer's office, although I wasn't in the office when the call came in, that he would be withdrawing and that Mr. Trusch's firm was going to be handling it, but that there is a strong likelihood that the trial would not be able to be commencing on February 26th. And I would advise the court, we jumped through a whole bunch of hoops. When I say we, I mean my office, jumped through a whole bunch of hoops yesterday to try and notify personnel that it may not be going, because obviously they may be required to appear elsewhere at the same time.
Mm-hmm. Okay. All right, so Mr. Evans, you know, we do have trial scheduled to start on February 26th in this case. You will have counsel. It'll likely be Mr. Trusch if Mr. Pfeiffer does in fact withdraw. And at that point, you know, you essentially will have 2 choices. We can continue and go forward with trial as scheduled on February 26th with Mr. Trusch. And I'm sure he'll do what he can to be prepared for that trial, or you or you through counsel would have to request an adjournment of that trial date. Do you understand that?
Yes, Your Honor.
Do you know how you're going to want to proceed?
I would, if Mr. Trusch is gonna be my counsel, I would request for an adjournment so he has time to prepare, because I would not want to go forward with trial with him not prepared. As comfortable as he would like.
All right, so Mr. Trusch, I guess I'm going to ask that you communicate with Mr. Pfeiffer again. We need to get Mr. Evans some counsel of record.
In fairness, I think my office did file an appearance yesterday.
Okay.
But again, the substitution hasn't been completed. And I would indicate, not that I expect this, but I mean, Your Honor could choose not to sign that substitution. Again, I don't expect it, but
right.
I mean, technically, until it's signed, I don't think I'm in.
Right, okay.
And judges, the Mexico trial is the other one that's running at the same time.
Okay, so I think, Mr. Rolla, we probably need to plan on going forward with the Mexico trial.
I anticipated the court saying that this morning.
Yeah, given the circumstances here, I think forcing this trial is only going to result in waste of court resources down the road and prosecutor's office resources, frankly.
Judge, I see no reason to create an appellate issue.
Okay, so we'll plan on the Mexico trial going. I'm going to leave this on the docket, however, Mr. Trusch, until you are actually in the case and Mr. Pfeiffer has filed his substitution. So Mr. Roll, I wouldn't cancel those subpoenas just yet, but
I'm not going to do that until
it's entirely possible, Mr. Pfeiffer.
Nothing personal, but
right. No,
until I get a court order, they stay out there.
It's entirely possible Mr. Pfeiffer could call tomorrow and say, oh, things have changed and we're going to go forward to trial and I'm ready to go. So until that substitution actually takes place, I'm going to leave everything as is, but with everyone with the understanding that the court is likely to grant an adjournment of this trial at the request of the defense and proceed with the Mexico trial.
Two things that I would, well, one thing I'd ask of the court, and then I want a clarification on an issue. So Mr. Evans is set to start a trial that I already represent him on
in March.
And I'm sorry, I for whatever reason I didn't know if it was in front of Your Honor or Judge Hunter. I didn't have it listed on the calendar. Yeah. What I would suggest is, can we set a status conference perhaps in the first week of March for both cases? I don't know that if there's a possible global resolution, because again, I don't know anything about this other case, but my view is generally the more things that are out there, the more moving pieces, the more likely it is that some sort of deal might be able to be worked out. And then I just wanted to clarify, once the substitution is done, is the court requesting that I request an adjournment, or is the court just gonna move the date to that?
I would request that you file for an adjournment. Given that it's at the request of the defense, given the circumstances, I'm more than likely going to grant that, but I think we need to have an order in place.
And again, I just wanted to make sure that I get the paperwork correct.
And I think that's a really good idea, regardless of whether there's any agreement or not. I think it's a really good idea to set all files for a status conference at the beginning of March.
And people have no objection to that from the judge. I just, as I said, I will have our MOPSnet call off 18 people, one of which we had to make special arrangements for to make sure he didn't leave for Florida until after being able to testify on the first day of trial.
Okay. All right. Mr. Evans, do you have any questions at all about how we're going to proceed?
No, Your Honor.
Okay. All right. Thank you. That's all for today. And we're going to disconnect at this time.
Okay.
All right. And that concludes our morning.